and my brain will go a little too fast, and my mouth is just like,
blah, 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 blah.
trying to wait a minute, rewind, let me back up.
Good afternoon, everyone. We are the Title Sisters with the Willingham Group. I'm Ashley Lindley.
And I'm Brittany Bell.
We are here with Kellyanne Beachley. She is our office manager and paralegal at the Willingham Law Firm. We are also in the same unit with each other, so we're the Willingham Group, as y'all know. Today, we are going to be talking about the importance of wills and trust, correct?
Yes, absolutely.
Perfect.
So it's really important for families to think about wills and trusts. So we want to talk with Kellyanne to get some insider information on why.
And most importantly for moms or soon-to-be mothers, really just families getting started, because a lot of us are young and don't really know the full process of what to do or why we need to do it. So she's going to go in depth and explain that for us today.
So first and foremost, I want to shoot down the misconception that no matter what age you are, you can't have a will. You only go get one if you feel you're about to pass away, if you have a health inclement problem, if something is bad is going on, or you're old. That is just not true. I have a 5-month-old son. I have my estate planning done, and I sleep better at night knowing that if something happens to me, he is well provided for, he's taken care of, and there is a list of people who will step up to the plate and do what I need them to do. All of that you can detail and outline in estate planning that we offer at the Willingham Law Firm. So, for instance, myself, I have a trust and a will that provides for my child should something happen.
We joked about that.
It's the most common
We
name.
joked the other day because somebody said Ashely, and every
Ashley.
time I read it, I say Ashley. Like,
I get Bertini,
Brittany.
believe it or not. Yeah. So Kellyanne, why don't you tell us a little bit about what happens if you do have children? What would happen if you didn't have something like that in place?
So if you do not have something like that in place, the state of Texas is typically the primary beneficiary if no one opens up something called a probate proceeding. And a lot of times, attorneys in Texas who open up probate proceedings require an upfront fee that a lot of folks, especially their children that they leave behind, don't necessarily have. After it doesn't have a beneficiary claiming, after 7 years, it goes straight to the state of Texas and does not pass to your children or any other loved one or heir you may have. So that's one easy way to avoid that. It's also a way to save your kids money. Like I said, that's quite a bit of money to initiate a proceeding like that. And if I had to do it today for my mother, I would maybe be able to swing it, but it would be very difficult, which is why I've encouraged her and she has followed through with making a will.
Oh, that's really important.
That's awesome. So I have a now 3-year-old, and say I actually did recently go through and do my estate planning with Taylor Willingham. He's our attorney here at the law office, and I put into place something for our daughter. So if something were to happen to my husband and I, she would be taken care of. So tell us, if we didn't have that and something happened to us tomorrow, what would have happened to our 3-year-old?
The state of Texas will place her in the foster care system. They have their hands tied. At that point, the laws of intestacy list out a list of precedented heirs that you and your husband leave behind who have the first and foremost right to take over guardianship and taking care of your child. But until a court and a judge determines who is going to do that and when they're going to do that, your child is placed in foster care, and nobody wants that.
No, that is very scary. Foster care is not something that you want your child going into.
Not when you can spend $200 to get a simple will and avoid all of that.
Right.
So that's pretty affordable.
Absolutely. If you just want a simple will, in a simple will, you can do several things. You can talk about what your wishes are for afterwards. If you wanted to be cremated, buried, you can indicate who you want to take care of your children, who can provide for them. You can indicate who's going to get the residue of your estate, which is your assets. It's a legal jargon for your assets. But if you don't do any of these, the state of Texas will step in and dictate how it's to be done. So it's a small amount, it's a small price to pay for such peace of mind.
Absolutely.
So say for someone, and in my instance, I'm an expecting mom, and my boyfriend and I aren't married yet or anything like that, but what are some things for those who are planning to have kids or expecting to have kids but don't?
So I want to give you an example. For, let's say, I know you have a boyfriend, you're not yet married though, and in the eyes of Texas, as far as the law is concerned, you are a single person. Let's say your bank account has $15,000 in it. Okay, let's say you pass away right after you have a child, okay, and you're not married. No one has access to that bank account, and either your child's father or your parents will have to pay anywhere between $2,000 and $5,000 to initiate a probate proceeding and let us into that. One trick, one thing in addition to having a will that I would absolutely suggest to anyone, it's a free thing to do. You call any financial institution you have, you call any financial account holder that you have, and you designate a beneficiary should something happen to you. Some places call it a beneficiary, some people call it rights of survivorship. You need to designate who you'd like that account to go to, and even if you passed away without a will, at least that account and the rights of that account would pass to someone you've indicated.
Okay.
And you do that directly with the bank.
You do that with the bank. You don't have to wait on a will to do that. A will takes care of the muddled gray area and all of the other areas of assets, finances, children, heirs that you may have. A will just kind of lets you really fine point, indicate what you want should you pass away. But one thing that is free to do and everyone needs to do today is call your banks, call your investment account holders, let them know I want to make a beneficiary on my account should something happen to me. What are you going to name your child? Do you know?
Rowan. Rowen.
That's beautiful.
E-N. I keep wanting to do A-N.
No.
Rowan.
Rowan. No, that's why we're not doing it.
Rowan.
Yeah. You do for single moms that are expecting a kid. Okay.
Absolutely. We can say that you are pregnant and expecting a child. We can just say that. If you have a name picked out, we can even identify the child's name. And then at that point, after you have your child, we would suggest you come back in, let us rework the will. They have things called codicils, which is an amendment to a will, and we can add in your child's name should you have not had a name picked out when we got your will done, or we can completely redo your will. And here for a redone will, we charge $75. So it's not like you're starting over from step one. You've already got the most of your information given to us, and we'll get you taken care of.
Oh, perfect. Okay.
All right, guys, so you heard it directly from the Willingham Law Firm. If you need a will, trust, or estate planning done, they are your go-to. They're awesome. I did it myself with my family, and it really gives you peace of mind. So thank you for tuning in to this week's Title Sisters video. I'm Brittany Bell. This is Ashley Lindley, and we will see you next time.